Hello, my name is Alma Robinson, and I am the Executive Director of California Lawyers for the Arts. CLA is a statewide nonprofit organization that was founded in 1974 to serve artists and arts organizations of all disciplines with advocacy as well as services that provide support with legal and business issues. With staffed offices in San Francisco, Berkeley, Sacramento, Los Angeles, and San Diego, we provide several core services. First, we provide legal counseling to specialized attorneys who provide assistance with a variety of intellectual property questions, as well as contract reviews and negotiations, and other important business issues. Depending on the client's financial status, legal assistance may be available on a pro bono or reduced fee basis. We also provide a specialized program that assists independent inventors and small startups with their patent applications. To help with situations involving disputes, we provide a range of alternative services, including negotiations counseling, mediation, and arbitration that can avoid the expense and hassle of going to court. Finally, we offer a full menu of educational programs that include workshops, symposia, and conferences on various legal topics for artists and arts organizations. Many of these programs are posted on our YouTube channel, and we encourage you to use these tools to educate yourself on the legal issues before you reach out for specialized assistance from our organization. Thank you for joining today's program, and please consider joining CLA on our website at www.calawyersforthearts.org so that we can continue to maintain our full range of services. Thank you.
How does copyright work with a published book? i.e., the publisher typically grants copyright to the author, and that will be stated in the front matter. So is that adequate in the case of going to court, or do you also need to register with the United States Copyright Office? Okay, so that's a good question. So it could work a couple different ways. One way that's very common is that the author of the book, so it's one author or multiple people, are the authors for the copyright purposes. Author is just a legal term that we use for the creator and owner of a copyright. So it may be that you write a book, and as soon as you write it, you own the copyright. As soon as you typed it out or wrote it out, it's boom, it's copyrighted. Certainly that a book, something of that length, should be registered with the United States Copyright Office. And then typically when you have a contract with the publisher will get a license from you to then exclusively publish the book, right? So in this case, you're the author, you own the copyright, the right to make copies and do whatever you want with that work is yours. You have chosen to give a contract, a license to this publisher. The publisher is paying you, assume, in exchange for the exclusive right to publish and sell copies of that book. You may have multiple publishers in multiple different countries, or it may all be one conglomerate or whatever. So that's kind of typically the way it works. So if you open, a typical novel or nonfiction book to the front piece, it'll say copyright, typically the name of the author. That's one way that books work. Another way that books might work is if the book is commissioned or you're contracted to create the book for the company. Then the author typically does not own the copyright. It's what's called a work for hire. So earlier I said, as soon as you create something, you own the copyright. You're the author, you're the creator of this original work, and you own the copyright. But there's, of course, exceptions. And the probably most important exception is work for hire or work made for hire. This is a term you might hear all the time, work for hire. So under the United States Copyright Act, if I pay you to create a work, let's say I pay you to write a book. If we don't have any other arrangement, I just say, okay, I'm going to pay you whatever, X thousands of dollars to write this book. You say, okay, you go off and write it. You give it to me. I pay you the money. You still are the copyright owner if that happens. I'm not. But if we have a written contract that has to be written, not oral, not handshake, but an actual written contract that has very specific language stating that it is a work made for hire, and you've signed that contract, ideally before the product is created or the book is written, then whoever is paying for it, whoever is the party on the other side of the contract, owns the copyright, not the actual author who wrote it. The person who paid for it, in this case, let's say a publishing company, they would be the author for the purpose of copyright law. In those cases, so let me give you an example of when that might happen. Let's say you get commissioned by Marvel Comics to write a book about Spider-Man. Well, typically Marvel is going to be the party that owns the copyright to that book, not the author. It's really maybe they're selling more of a product based on a popular character than they're selling the author. It's not like J.K. Rowling or something where everybody knows, okay, this is a popular author. I like her other books about Harry Potter. I'm going to go buy this book. No, they're buying Spider-Man. They're buying the product that is owned by Marvel. They've commissioned a writer to write a book just as they might commission an illustrator or anybody else. It's a work for hire deal. You get paid whatever the terms are of that contract, and that covers that. In terms of the second part of that question, is that adequate in the case of going to court and you also need to register with the Copyright Office? You always, 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 always need to register a copyrighted work with the United States Copyright Office if you want to go to court. Always, 100% of the time. If you want to go to court and protect your rights, you need to register your work with the United States Copyright Office. There was a recent court case, I think it was last year, I wrote about it on my blog, that really clarified this, that you cannot go to court no matter what I do to your copyright, no matter how I rip it off. You can go to court for other things, breach of contract or some other kind of claim. But if it's specifically infringement of copyright claim, no matter what I did, if you don't have that registered with the United States Copyright Office, you cannot walk into court. It just doesn't, it's like it doesn't work. So the answer to the question is yes, the granting of the copyright or stating of in the front piece of a book who is the author for the purpose of copyright, that's important, but it does not substitute for registration with the United States Copyright Office. If someone has an idea for a TV series and one writes a Bible that includes treatment, synopsis, and a summary of each episode. So a Bible is just a term used in the television industry for like kind of the book that or document that describes the main thing about the show. Like it's called The Sopranos. It's a show about the mob. There's a guy called Tony Soprano. He's the head of the family. He has 2 kids and a wife, blah, 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 right? That's like the Bible of the show. Can that be copyrighted? And if so, how does one copyright it? I called the Library of Congress. They said if it's a concept, it can't be copyrighted. Is there any way of protecting that IP, or unless one has a full script for first episode in each and every episode, no copyright can be requested by the Library of Congress? It's true that copyright does not protect ideas. That is absolutely true. So the concept of, let's say, a TV show about the mafia, that's an idea. Nobody can own that. I can go make that show tomorrow, right? However, the individual unique expression of that idea is protectable by copyright. But it needs to be written down or created somewhere, typed, written, whatever, saved somewhere. It needs to get out of your brain in order to be copyrighted. You can have the best idea, the best story, the best song, the best whatever in the world in your head, but unless it's out there in the real world somewhere on a computer or a page or something, it's not protected by copyright. It needs to be out there. What's locked in your brain doesn't do anybody any good. So if you write a show Bible that is a treatment, synopsis, summary of each episode, I would say, again, I'm not providing legal advice in this, but from what I'm understanding of your question, that is certainly a literary work that is the subject of copyright and protectable by copyright. The fact that every single episode of the series isn't written to, the last degree, that doesn't matter. That's yet to come. But if your show Bible has characters, it has a story, a synopsis, summary of each episode, that's a story. And that certainly should be sufficient for copyright protections. That would be, you would go to the Copyright Office, copyright.gov, you would file it as a literary work. If it hasn't been published anywhere, meaning nobody's seen it, it hasn't been put up online, and hasn't been shot and turned into a TV show, etc., it's an unpublished work, which can still be protected, but there's different ways to file these things, etc. But my understanding, based on your question, is that yes, sounds like very much a work that can be protected under copyright law, even though every single episode hasn't been written. Now, if you go ahead and write subsequent episodes, whether on spec or you're paid to do so or whatever, yeah, each of those scripts should also be filed with the Copyright Office. It's very easy. It's not expensive. But if all you have now is this show Bible that includes a synopsis, like a summary, like a paragraph or 2 about each episode, here's what happens, this person meets this person, they have this conflict, they resolve it, etc., I would register that as a literary work with the United States Copyright Office.
You said that if I write a book, I own the copyright as soon as the book is written, but then you said I need to register the book to have a copyright. Could you explain this? It seems contradictory.
There's 2 different things that happen in the copyright world. There's who owns the copyright, that's number 1, and there's whether or not the copyright is registered with the United States Copyright Office. Those are two different things. There's who owns the copyright, who is the author for the purpose of copyright law. And then there is whether or not that work is registered. Okay? So as soon as I create a copyrightable work, whatever that is, as soon as I've created it and it's out of my head and into the world in some context, that copyright law magically applies. As soon as you do it, boom, you are the author, you own the copyright. Nothing more needs to be said. Okay? That's number one. Number two is, what about registration with the United States Copyright Office? You don't have to register every single copyrightable work with the Copyright Office, but if you want to go to court, so if you actually want to sue or you're in a lawsuit that has to do with the copyright around your work, that work needs to be registered with the United States Copyright Office. Now, let's say you create a work, whatever kind of work it is, a book, a photo, a painting, or whatever, and it has some success and there's some material monetary value attached to that, and somebody rips it off, and you have not filed the copyright with the United States Copyright Office. Well, then you can go to the Copyright Office at that point and you can file an application to register that work. And you can actually pay for it to be expedited, meaning it gets done in a couple of days. So it's not like you're waiting forever to go to court and to claim your rights. However, number one, there's a fee for that, a rush fee, and it's like $800. It's not cheap. So a client just had to do that the other day. That money didn't go to me. That money went to the Copyright Office, and they had to do it, but they weren't thrilled about having to pay the extra money. And if they had registered it earlier, they wouldn't have had to. That's number one. Number two is that, and there's exceptions around this, but let's just talk generally. You can only claim damages, meaning the money that you get back from somebody who ripped you off, going back to the date of registration or the date of filing of the copyright. So again, just kind of giving a very simple example. Let's say you do a painting, right? You make a painting, and then somebody uses, that painting is hanging somewhere, somebody's house, whatever, and that painting is used, let's say, in a movie. Without your permission, you didn't give permission, it's used prominently, you didn't give any license, you didn't, et cetera. Let's just assume this example, that there's no weird details about it, and that you have a claim against the movie production company for using your work without your permission. Okay. So if you registered the painting with the Copyright Office way back when you created it, boom, no problem. You can get a lawyer, go to court, sue the movie company, and collect your damages. However, if you did not register that copyright, now you have to go and register it, and you may not have access to the monetary damages that you would otherwise be entitled to, because those damages may have occurred prior to the date of filing the copyright registration. So again, I know some of this might be technical, but the point is, if you have a work that has some value and it's substantial work, you really want to register it with the Copyright Office, because number one, unless you do that, you won't be able to go to court. And number two, if you do want to go to court, you may have to file and get it expedited, which is going to cost you a bunch of money. And number three, you may still lose out on the opportunity to access some of the damages, the money that's owed to you, because you waited too long to file the copyright registration. So register your copyrights, bottom line. I composed a musical piece, then recorded myself performing the piece. Should 3 separate copyrights be registered for the composition versus my performance versus my ownership of the recording? Okay, so good question. Music copyright is a whole nother beast. We can certainly talk about that. So there's actually 2 copyrights, not 3, that you need to worry about in terms of music. So the first is the copyright that attaches to the song. So you've written a song. It might just be music, so like notes on a page, something like that, or any kind of music, electronic music, rock, whatever. Or it could be music and lyrics. But let's say you've written a song. The copyright attaches to that composition before anybody even records it. So if you just write a song down on paper with musical notation or however else you want to write it, guitar tablature, there's all different types of ways to, put music on paper, right? Or on a screen. Even if you've never performed it and nobody's ever performed it, there still is a copyright that attaches to that musical composition. So that potentially should be registered if it is something that has potential commercial value or you want to protect it. Then there is the copyright that attaches to the recording of a song. Those are 2 separate copyrights. So there's the musical composition, and then there is the recording of a song. Now, one song, of course, could be recorded thousands or however many times, right? So think of the Beatles or Duke Ellington or whoever, Taylor Swift, I'm sure, anybody. You could go on YouTube and find people doing cover versions of every song that's ever existed. Each of those is a unique recording. So you might have one song, right? Like Happy Birthday, but you might have a million different cover versions, each person doing their own twist on it in a different style or their own voice, etc. Each of those recordings is a separate copyrightable work, even though there's only one underlying composition that might be owned by whoever. So you composed a musical piece, you recorded yourself performing it, should separate copyrights be registered for the composition and your performance, which is, the performance is really captured in the ownership of the recording. So there's no separation between the performance and the ownership of the recording. They're the same thing. So yeah, potentially there would be a copyright protection. There'd be advisable to register the original composition. And lyrics might also be a separate copyright. So now you are really getting to potentially 3. If there's lyrics, that would be a literary work, like a poem, same thing. And that would be a separate potential filing. And then the registration for the actual sound recording. How does copyright registering work if you write under a pen name? So you can you can register a copyright under a fictitious name. You just need to say that it's a fictitious name. You don't have to say your own name. If you're writing essentially anonymously or pseudonymously and you don't want your name out there, that's fine. You don't have to reveal your own real legal name in the copyright filing. There may be other ways to identify you, like you're putting an address or you're putting other things in there. People may be able to figure it out one way or the other. But yeah, you can register a copyright under a fictitious pseudonym or whatever kind of name you want. What is the best approach for registering a comic book limited series? Is the first issue enough for protecting the series before submitting to publishers? So when you're talking about a series of works, copyright is really a basket of rights. We say copyright like it's one thing, but really there's several rights embodied in copyright. One of the most important rights that's embodied in copyright is the right to control or prevent others from creating what we call derivative works. So a derivative work is any copyrightable work that derives in part or in whole from a prior original work. So what that means is, like, let's say, take a look at Batman, right? There's tons of Batman movies, there's comic books, there's books, there's everything you can think of that has to do with Batman. Toys, all this stuff is derivative works going all the way back to the very first original Batman comic in whatever, 1930, whatever. So imagine the authors, Bob Finger, Bill Kane, they create the first ever Batman comic. That's the original work. Every single other iteration of that movie, TV show, comic, whatever, is a derivative work of that original. They all flow from that original kind of stream. So the answer to your question is, if you've got the first issue and that's done, created, written, illustrated, whatever, then, of a comic book series, then you definitely want to register the first issue with the Copyright Office, because that will prevent others from creating unauthorized derivative works. So if somebody says, hey, I like this, I want to publish this issue 1, and then create issue 2, 3, 4, 5, 6, well, those are all derivative works of the original, and they cannot create them without your permission. And again, having that copyright registration allows you to enforce those permissions. So I would definitely do that. Now, if you have the other issues already created, then you may want to register them as well. And it's possible to register a series or collective works in one registration filing. That's kind of outside the scope of this conversation, the kind of nitty-gritty details of the Copyright Office. But you might want to consider that if they're already created. But if you've only created the first one, and then you want to work with a publisher to go and create more of them, then go ahead and register that first issue, and then that should protect you from somebody going ahead and making additional versions of the same one, same story. Could you speak on the artist/gallery relationship? What details might you include in a contract between them, particularly concerning the sale, showing, and marketing of works of art? Any artist that is working with a gallery, you want to make sure that it's just clear what rights they have in terms of the art. It sounds like you kind of have a good sense of this already. For example, if the gallery is going to market the art, where are they going to market it and how are they going to be able to do it? Can they take pictures? Let's say it's a work of visual art, I'm assuming. So can they take a picture of it and put it up on Instagram or, I don't know, TikTok or whatever people use these days? If so, what are the contexts between that? They assume they have to attribute the rights to you as the artist. Can they only do that during a certain period of time or until the work is sold and then they have to take that down? Or can they leave that in display forever? What about the sale? Do you want people to be able to take pictures of the work? So if people are walking into the gallery and they pull out their phone and they take a picture of it to, whatever, post on their social media or send to their friends or whatever, do you want them to have the right to do that? The gallery can control that. They may have their own policies, but you need to understand what those are and to make sure that you're advocating for what you want them to do. As far as the sale, those terms really have to do with, what the negotiations are. Presumably you're going to set a floor, okay, you can't sell it below this amount of money and maybe some time, like, if it hasn't sold in X number of months or some period of time, then the artist has the right to take it back. Those might be common terms that come up in these types of situations. If you get hired to create a video for a client, can you share it on your YouTube channel? Is it something you should put in your contract with them, even if it is a work for hire contract? If you get hired to create a video for a client, can you share it on your YouTube channel? If it's a work for hire, meaning they own it, and you don't own it, you're just doing the work for them and they own the copyright. You can only share it on your YouTube or anywhere else if they give you that permission. So yeah, that should be in the contract. And I see that all the time in contracts, that artists have the right to share it on Portfolio, or they share it on YouTube, whatever else, social media. Often that is controlled in terms of time, meaning the client, whoever's paying to create the work, has the sort of exclusive right to launch it. So, meaning you can't share the video until the client has put it out there because they're paying for it. They want to put it out there and launch it. And then once it's out there, you can say, hey, I'm the artist who created this. I'm the video director. I'm the illustrator, animator, whatever it is, and I can share it. But yeah, you want to make sure that that right is written in black and white in the contract. Otherwise, you technically can't do that without their permission. There's some gray area around that, in the sense that, let's say your client puts it up on Twitter. Well, you can retweet on Twitter. Anybody can retweet anything. So there's nothing stopping you from doing that. And that's within the Twitter terms and conditions. Same thing with Instagram, sharing, et cetera. So most of these social platforms have some kind of sharing function. So to the extent that they're putting it on their social media and then you're just kind of resharing it, or, whatever the term is in that particular social media, you may be able to do it in that context. YouTube, not really, because YouTube doesn't really work that way. So yeah, I would make sure that if you want to use it in your portfolio, on your website, on your YouTube, on your whatever, that you ask permission. And if you're the artist and the creator, don't restrict yourself, because you don't know what tomorrow's YouTube's going to be, right? Like 15 years ago when YouTube was created, there was no YouTube. So don't just say you can share it on your YouTube or Instagram, because maybe tomorrow everybody moves off of Instagram and onto something else. Just say social media channels or online or portfolio. Try to be general about it, because that way you're not boxing yourself and preventing yourself from sharing it in a future medium that might be advantageous for you in terms of securing future employment. If you register a novel halfway through the process and then make extensive edits, but it's still within the same story world, do you resubmit your copyright with each update? So typically, in my experience, novelists or authors don't usually submit the copyright, so don't register a work until it's done with the Copyright Office. There may be some exception where you would do it beforehand because you are scared somebody's going to rip you off, or they're in some kind of dispute about it. So you want to make sure that whatever version you have right today is registered right away. But those are going to be exceptions. Typically, you just want to wait till it's done. If you have, but maybe you write a novel and then you register the copyright, and then 5 years later you go back to it. You're like, you know what? It needs a better ending. It needs this. It needs that. I'm a better writer now, so I'm going to change it and do a new revised version of it. That's fine. Then it would be a new copyrightable work. So anytime you're making any kind of substantial changes to a work, the copyright that's registered only applies to what's registered. It does not apply to additional, versions. If we're talking about a minor editing, oh, I forgot to capitalize this or put punctuation in it or something like that, then you're not filing a new copyright. That's de minimis. But if there is some substantial change where, okay, like you said, extensive edits, that would be you would register that as a derivative work of the original copyrighted work. So it's a new copyright filing. If I take a photo of a three-dimensional object in a museum, it was okay to photograph it there. Does my specific angle, lighting, and cropping of the photo allow me to, number one, copyright it, and number two, sell the photo in any form I choose, e.g. on metal, canvas, etc.? So yeah, I would say yes. I mean, technically you probably own the copyright of that version of the photo because you have your own angle, lighting, and cropping. Now, with that kind of thing, it becomes really hard to tell if it's minimal creativity or not. Is it, did you find some unique way to frame it or to pose it or light it where it just conveys some specific impression as opposed to like I'm standing in front of the picture, I took a picture, boom. But remember, the original work is protected by copyright law, whether it's owned by the artist or a gallery or museum or whoever. Somebody owns the copyright, presumably, to that work. If it's a more recent work, if it's an older work, like let's say before the 1920s, then Michelangelo or something, then it's in the public domain, and basically the answers to everything you said are yes. But if it's a more recent work and the copyright is owned by somebody, then your photo of it is a derivative work of the original. And so it's okay for you to take the picture, whatever, but from a copyright perspective, if you were trying to protect your version of it, and to sell it, you may be making unauthorized derivative works of the original, and that is a copyright infringement. So not only can't you protect the copyright in your photo, but by making copies and selling them and distributing them, exploiting that work, you may be infringing on the copyright of the original artist or whoever owns it. So the answer is a little different, I guess, depending on the age of the work and whether it's in the public domain, meaning it's really old, or whether it is something that is a more recent work that is still subject to copyright protection. Whether or not something is in the public domain, it's very complicated, and it's different in every country, and it's different prior to 1978 and after 1970, and there's all different permutations around that. So just assume that something, unless it's really old, like before 1920, always assume that something is not in the public domain, that it is protected by copyright, and so you would need permission of whoever the copyright holder is to be able to copyright your work and to exploit it. There are books that contain generic contracts for artists. Do you recommend using these types of contracts? If some of these books are better than others, what would you recommend looking for? Do you have a recommendation for a contract source? I don't know anything about most of those books because I've never looked at them. I don't, so I can't recommend one or the other. Look, you're an artist, you're in business for yourself, or you're starting a business, whatever it might be. You have to make whatever decisions you can make based on your budget and your circumstances. Of course, I find that a lot of contracts that are out there, that are accessible either in books or on the internet, have varying levels of quality. Some are good, some are not great. So I can't tell you in any specific example of what works and what doesn't. Ideally, sure, you would go out and hire a lawyer right away to, that's really experienced, that can write a really good, solid contract for whatever you need. That may not be the case. There might be other resources available. California Lawyers for the Arts may have resources available. There's other entities out there that can provide resources to artists and others who are, depending on your socioeconomic status or other things, may need access to resources. But short of that, yeah, I mean, you can find a book and you'll just kind of have to judge for yourself about the quality of it, because I just wouldn't know. Do people who shoot video own the copyright to it, meaning they can use it in other projects, even if it is a work for hire? What if there is no contract? Let's answer those questions in reverse. What if there is no contract? If there's no contract, meaning there's nothing written, and it has to be written, then it's not work for hire. It's just not. Period. End of story. It is not work for hire unless there's a written contract. That's what it says in the United States Copyright Act. If there is a written work for hire contract, then the person who did the work, in this case, somebody who does video work, does not own the copyright because it was a work for hire. If it's a work for hire, then the person who's doing the work doesn't own the copyright. The hiring party does. So the company, the client, the whoever who paid for it, they own the copyright, and they can do whatever they want with it, subject to whatever terms are in their contract. I guess the answer to your question is no. You said, do people who shoot video own the copyright to it if it's work for hire? No, that's those two things are the opposite.
Given the current necessity to work from home, many teachers are now providing their services through online video platforms. Their existing employment contracts may not have clauses that discuss what a teacher is obligated to do with regard to this new arrangement. Should entirely new contracts be drafted?
I would always want to be clear if you're doing work, sort of virtually or using an online platform or something, about who owns the rights to the recording, who can do what with the recording, etc. You definitely need to be clear about that. And so I wouldn't advise you just to kind of let it be without, kind of being specific. In terms of having a new contract, I mean, that is very dependent on the circumstances. You might need to have a new contract in place if the circumstances of how you're delivering this services are totally changed. But you might not. I mean, it might be possible just to say, hey, we have this contract in place. All the terms are basically fine, but now that I'm doing this online, I just want to be clear there's no recording. Or if you record it, you can use it internally, but you can't share it. You can't do this. You can't put it on social media, whatever the terms you want those to be. And that could even potentially be in an email. As long as it's acknowledged by both parties, the other party responds and says, okay, yeah, that's fine with us, no problem. That might be sufficient. And again, I'm not giving legal advice. Every circumstance is different, but that may be an example of a way to avoid having to do a whole new contract in that kind of situation. Can you speak on how we see trademark like Coca-Cola and Campbell's Soup in art? Is this not considered infringement? So generally speaking, the issue in trademark law is when somebody is using your brand name or your logo or whatever in connection with competing or similar goods and services. So if you wanted to use, Coca-Cola or the Coca-Cola logo to sell soda or drinks or whatever, you're out of luck. But it's a little hard with famous marks like Coca-Cola, Campbell's Soup, whatever. If it's a less famous or less well-known trademark and you're using it in a different context entirely, that might be okay. However, so that's the trademark side, but it gets confusing because logos are subject to trademark law and copyright law, right? Because they're a trademark, they identify the source of a good or service, so let's say soda or soup. But they're also a work of visual art, which is protectable by copyright law. So again, a logo can be protected under both trademark and copyright law. I know I said those are two different things, they are, but in the case of logos, they come together. So you could, even if you're not infringing on somebody's trademark because you're using the logo in a context that is not related to the original goods or services, you may still be infringing on the copyright if you're using the logo without permission. It's just like any other work of art. It just happens to be a logo. So how and why is it used in art? I mean, you're probably thinking of Andy Warhol. He was like one of the most famous artists in the world. And, I don't think Campbell's Soup had any objection to Andy Warhol using his work. I would certainly say there's also exceptions to the copyright issue, one of which is fair use. Now, this is a huge topic that I could not possibly cover in, 10 webinars. So I'm not going to be able to cover all of it right now, but everything I said about copyright law is true and applies, but there's also an exception, fair use. So we have copyright law, which protects artists and creators and companies that hire artists and creators and gives them certain rights to prevent others from making copies without permission. But then we also have the First Amendment, and those both apply. They're both in the Constitution. Copyright law is in the Constitution, and the First Amendment is in the Constitution. So they're in conflict, right? Because there's freedom of expression, freedom of speech embodied in the First Amendment. So that's resolved through something called fair use, which is a defense to copyright infringement. You can't claim fair use. You can't say, well, this is fair use, so I get to use it. It doesn't work that way. Fair use only applies when you've been sued for copyright infringement, and then you enter as a defense in court that this was fair use. That's the only time that fair use comes into play. However, arguably, using some kind of logo or some other piece of, corporate work, whatever, in the context of a, painting or work of art is transformative and would satisfy the fair use requirements. So if you were to use, if you're a painter and you were to use a corporate logo in a piece of art, and they were to sue you for copyright infringement because you used their logo without permission, you may, and I'm saying may, underlined, and it's in bold and italics and bright red letters that are flashing, you may have a defense of fair use depending on the context of how it was used and depending on many other factors. So I hope that answers your question, why that probably isn't trademark infringement and may also be defensible under copyright law. Do I need to put a copyright symbol on a painting or photograph? It could distract from the work. Do I need to put the year? If I want to register a work of art for copyright, I don't know the creation date, year of paintings I did years ago. Do I need to put something down? You do not need to put the copyright symbol on a work of art at all. The copyright symbol is the C in the circle. As soon as you create something, you are welcome to affix the copyright symbol to your piece. You do not need anybody's permission. You don't need to register it. You don't need to do anything. The moment of creation, you can stick that copyright symbol next to it. And you can also, the trademark stuff, let me just go over the trademark symbols because it's also pretty simple. So I know they're not related, but I just want to make sure that we're being clear. So there is the copyright symbol, which is the C in the circle, and then there are essentially two trademark symbols. One is the R in the circle. That says that this is a work that has been registered with the United States Patent and Trademark Office. So until and unless you have an actual registration, like a registration certificate from the Trademark Office, not a filing, not an application, but a registration, you cannot use the R in the circle next to your trademark. However, prior to that, at any point, you can use the informal or common law trademark symbol, which is the letter TM. That does not say that you have a registered trademark. It's just saying, hey, this is my brand name, it's my trademark, my logo, my whatever. You don't need anybody's permission to do that. You don't need to file anything, whatever. There's also service mark SM, which is sometimes applied to services. You see TM more often. I usually just use TM. But that kind of covers the trademark side. The copyright symbol, you can use it, but you are not legally required to use it. Now, is it a good idea to use it in some contexts? Yes, because it tells somebody that this is a protected work and who owns it. But you don't lose copyright if you don't use the copyright symbol. Now, you asked about the date, the year. So the proper way to express copyright, if you want to use the copyright symbol, is the letter C in the circle, the copyright symbol, and then the year of creation, so 2020, and then the name of the author for copyright purposes. So it might say copyright symbol 2020 David Lizerbram, if I'm the author. Or it might say copyright symbol 2020 David Lizerbram Associates, which is the name of a law firm, if my firm created something, right? So the name of the author could be one person or multiple people, or it could be a company, or it could be a nonprofit, or it could be whatever, but that's the order: symbol, year, and name. And again, you are not required to do that. You don't have to say all rights reserved. All rights reserved doesn't mean anything. I don't even know why anybody puts it out there. That's like old school. You don't have to say all rights reserved. Your rights are already reserved, so don't worry about that. But in terms of the actual copyright symbol, you don't have to put it. I wouldn't put it on a painting or photo because it's distracting. You can use it as a watermark if you want to use it in that context, but you don't need to. You might want to, put that information in the back of a photo or painting or something like that if it's being displayed, or, whatever, but in a gallery, but you don't need to put it on the work itself. You also asked, if I want to register a work of art for copyright, I don't know the creation date, year of paintings I did years ago. Do I need to put something down? Yeah, I'm trying to think about that. That's a good question. I'm actually not sure what the right answer is. I mean, you don't want to go too far back. You don't want to go back before, so you might want to put, the latest year you think it might have been. But there's probably a rule. The Copyright Office has all these documents that are available at copyright.gov that kind of try to explain these things in pretty plain language. They're not really meant for lawyers. They're meant for regular human beings. You might want to look on the Copyright Office website, copyright.gov, to look that up, because I'm not actually really sure what the guidance is for that. When filming documentary shoots in streets, capturing logos, am I infringing on the many trademarks of ads on the street? It's not really infringement of a trademark. It's not really a trademark issue, really, in terms of what you're talking about, because you're not using those brands as a trademark. So if you're shooting a documentary and somebody drives by in their Toyota, well, you're not selling cars, right? If you're selling, if you have a car company or it's a car commercial, that's one thing. But if you're it's a documentary about people in the street or people, whatever, that's not infringing on Toyota's trademark by happening to show the Toyota logo as it drives by, because you're not in conflict with them. You're not using their mark to sell services. There's no implication that your documentary is sponsored by Toyota or something like that, so generally speaking, that's not really an issue. Likewise, if you're, walking through the mall and shooting a documentary and you see the Gap, you see Banana Republic, you see whatever stores there are, same thing. You're not selling clothes. You're not selling the products that are being advertised using those logos. You're just incidentally, they happen to be there and it's a public space. It can get more complicated with works of art. So street art specifically can be very complicated in terms of use in documentaries and things like that, because that's protected by copyright. So, if you're just quickly shooting, a panorama of a city and, it happens to have there's a mural or there's street art, but it just goes by really quickly, maybe that's probably not an issue. Not that I've seen typically, but if you're shooting something where, like say a piece of street art is prominently displayed and an important part of a scene, then you would want permission from whoever owns the rights to that street art, which might be the artist, might be whoever, could be the owner of the building commissioned it and they to work for hire, they might own it, you don't know. You would want permission to copy it, to use it in your footage. And then whether that footage is being used commercially or just for kind of a hobby thing, there's a lot of different factors here. So I know that wasn't a comprehensive answer to your question, but that's probably the best I can do. Can students use an existing copyrighted work when creating for education? They use copyrighted music in their video. Is there a time limit? Can they share on social media? Number one, there's no time limit. So if anybody ever tells you, you can use 7 seconds of music, or you can use 10% of this, or 20%, or whatever other number, walk away from that person, because they are not telling you the truth, or they don't know. They're not an expert. They really don't know this stuff. I know probably there's people out there that are listening to this that have heard that in the past by somebody that, is really trying to give you good advice, that you can use 10 seconds of a song, you can use this part, you can use this amount of a video, whatever. None of that is true. I'm just here to tell you it is not true, okay? Not to say that you can't ever use anything. There might be fair use, but there is no specific law anywhere written on any book that gives you a percentage or amount of time or anything like that about use of a copyrighted work. It does not exist. It's totally based on the context of what you're using. There have been successful lawsuits over the use of the tiniest fragment of music, and even a successful lawsuit in the Blurred Lines case, the famous song with Pharrell and whatever, that just kind of copied the vibe of a Martin Gaye song. It wasn't even the original music. It was just kind of a similar vibe, and they got a lot of millions of dollars from the court. It's being fought over for years. So in terms of students, I would say, generally speaking, educational use typically falls under the scope of fair use. So if your students, let's say they're in high school, college, whatever, they want to make a music video to learn editing or learn some editing software, and they want to just lay some, popular music over it, typically I would say that's fine. I mean, the reality is that music companies are never going to know, probably. And if they do, they're not going to shut down, tell some students not to do it for just purely educational purposes. Probably every single student in every film school, I went to film school, we certainly did that. And probably every single film student in the world does that. And I've never heard of it being an issue. Now, can they share it on social media? That's where it gets tricky. And the reason is that social media sites have algorithms to detect when there is music, copyrighted, popular music in a video, and they will take it down. YouTube especially will take things down if their algorithm, just crawling through all the videos, finds music that they don't think you have the permission to use. So that may be an issue in terms of putting it up on social media, just because it might get taken down. Or they could get a takedown notice, meaning the company that owns the record company, let's say, that owns the recording, or the composer who owns the song, may submit a takedown notice to Instagram, YouTube, TikTok, whoever it is, and then the video will just get taken down, basically, because the companies don't want to get sued. So bottom line, for educational purpose, like you're discussing, I mean, I've just never heard of any company suing or having a real issue. That doesn't mean it's never happened. I've just never heard of it. So I think that's, probably so common that I wouldn't really worry about it. But if they want to share it online, they may run into issues. I mean, they're probably not going to get sued, but they may want to run into issues where the videos are taken down either automatically or because a copyright infringement notice was submitted and it gets taken down. And that is the last question that we have. So I have answered every question that anybody has ever had about copyright, trademark, artist rights, contracts, etc. Well, thank you guys very much. Everybody who asked questions, that's really what makes this rewarding, is being able to answer people's questions and hopefully give them some guidance. Like I said, I've got a lot of resources on my website. If you have other questions or other things, you might find answers there. I have a book called Podcast Law. So if you're involved in podcasting, you can go to podcastlawguide.com. That's available for free. Thanks, guys, gals, and non-binary pals. Thanks, everybody. I appreciate it. Support California Letters of the Arts. They're great.